introduce you first. Legal corpus linguistics, and the people who have joined me last time, they will already know the slides I will present you now, so sorry for the repetition, but I promise it will be brief and short, and then I will dig deep into today's topic right away. So legal corpus linguistics, fundamentals. Why would you blend corpus linguistics and law at all? And just as last time, I want to talk a bit about my theoretical background and where I'm coming from. So the law, I believe, and I'm building on Niklas Luhmann right here, builds a social system, a legal reality, right? So legal propositions, legal provisions, they are typically ought propositions, right? They consist of an ought using modal verbs such as shall, ought, of course, may, and all these modal verbs, they can be summarized as ought provisions. For example, a murderer ought to be punished, a contract ought to be in written format, right? So this is, I believe, the linguistic essence of legal propositions. And these legal propositions now, being ought propositions, they nevertheless create an is, they create a reality, a legal reality. And so this legal reality can be observed empirically, right? We can observe in a social system created by the law that certain contracts are valid only if they are in a certain format, like in a written format, right? And so this legal reality can be observed using empirical methods. And by my reference to law as using modal verbs, you can already see that the law itself is strictly dependent on language, both concerning its existence and scope. Only when we know what written form means, we know how far the legal reality we want to observe goes. So we know which contracts are covered by a certain propositions, right? Or only if we know what a murderer is, we know who shall be punished and who not, right? And so this strict dependency on language, I believe, is the foundation of the intricate relationship between law and language, and also the foundation of legal corpus linguistics. And just to make it a bit more precise and less abstract, I want to show you a few counterparts between law and linguistics to once again highlight this intricate relationship between law and the language. So, for example, if we observe the legal reality that a court decision can be appealed, right? In Germany, for example, in criminal proceedings, the accused person always has to be present, and if the person is not present during criminal proceedings, then a court judgment will be void. This nullity of a court decision can then be subject of appeal proceedings. So this is the legal reality we can observe, right? So these are the legal facts. We can systematize this. We can use theoretical models to systematize these conditions for an appeal within legal doctrine, within legal theory, right? We can observe under which conditions certain court decisions can be appealed. So this would then be our model for legal systematizations. And these then have counterparts in linguistics. For example, in speech act theory, court judgments, according to Austin and according to other scholars, they form so-called speech acts insofar as they create legal realities when they are uttered. I hereby pronounce you man and husband. I hereby sentence you to 10 years prisons, right? These are special linguistic properties of so-called speech acts. They create a reality. And these speech acts, they are only valid if they have so-called felicity conditions. And these felicity conditions, they are, in the case of court judgments, ultimately the same legal conditions for the validity of a court decision as in the legal systematization, right? And so this shows, I believe, beautifully how law and language is very closely related, and how legal propositions build on conditions of validity in linguistics. And the same is true, and here I'll use a bit of a simpler example. For example, in the law of damages, in the law of awards for damages. An award for damages must be appropriate, as we all know, right? And in legal doctrine, in legal theory, this appropriateness then follows from a weighing of interest, right? A damage might be more pronounced, but a damage might be larger, for example, if someone who professionally plays the piano loses a finger, whereas for a law professor, arguably, this might not be the case. And in all of these cases, we try to determine the appropriateness of an award for damages by weighing interests. And we do basically the same in linguistics, where we try to disambiguate certain terms through the context. And here, once again, you can see that legal and linguistic thinking are closely aligned. Now, with all of this theoretical background in mind that you don't have to share, of course, in order to also consider the use of corpus linguistics a valid proposition, but I think it's an interesting theoretical proposition. Nevertheless, with all this background in mind, let's now talk about legal corpus linguistics. And now corpus linguistics, as most of you probably know already, addresses linguistic questions empirically by using large and representative corpora of the linguistic target population. And so a corpus is basically just a collection of texts. And the most important thing about a corpus is not that it just collects texts, but also that it is representative for a certain linguistic target population, such as general language use, written language use, spoken language use, and we can dissect that even further depending on the population we want to represent. And corpus linguistics can address all kinds of linguistic questions. So, of course, also linguistic questions in morphology or phonology or syntax and so on. However, the most important two branches of linguistics that us as lawyers are interested in is semantics and pragmatics, since it relates to the study of meaning, and pragmatics in particular, since it relates to the study of contextualized meaning. Now, these linguistic questions, we can ask and answer all kinds of linguistic questions, but in particular in semantics and pragmatics, we tend to use and reuse certain techniques over and over again. And just to give you a feeling for these techniques, these methods, I'm going to present you a few examples on popular corpus methods that will also reoccur later in the research study I want to show you. Now, the first one is frequency analysis. Just right here, I'm presenting you with a very basic frequency analysis. When we consider the use of awesome in a diachronic manner, so over time, then we will see that it used to be used way less frequently in the 1990s compared to today, primarily in spoken and magazine genres in American English, which might be an intuition that you might have had anyway. Now, collocation analysis, something else that's quite interesting. We consider terms that occur frequently and exclusively in close proximity to a certain term of interest, a so-called node, right? And right here, I'm presenting you another example. When we consider the collocations of the term cause, then we will find that other terms such as trouble, damage, and pain are frequent and also exclusive collocates of cause, and therefore framing it in a negative manner, right? So we have a negative semantic prosody with respect to cause as a term. Now, another thing we can do is concordance and n-gram analysis. For example, we can consider the contexts that are most prevalent surrounding a certain node, a certain search term, such as climate change. And we'll then consider the contexts that are typically surrounding it in a certain span, such as 5 or 10 words to the left or 5 and 10 words to the right. And then we will see which contexts typically surround it. And we will once again be able to determine this aura of meaning surrounding a certain node. And if we're precisely interested in reoccurring word patterns surrounding a certain search term, then we are talking about n-gram analysis, and we'll then find that certain terms reoccur in certain phraseological forms over and over again, such as impact of climate change. This would then be a 4-gram because it consists of 4 words, or climate change adaptation. This would be a 3-gram because it consists of 3 terms, right? So, and here, once again, you can see how we can determine an aura of meaning surrounding certain terms. Another thing that's quite interesting that I tried to do in the research project, I'm going to present you in a second, but it wasn't successful there, is keyword analysis. And keyword analysis is something where we compare 2 corpora and then try to determine what's special about one discourse that is represented by one corpora vis-a-vis the other one, right? And for example, if we compare a English football corpus with general British English, then no surprise, we will come up with terms that are specific to football discourse, such as goal, striker, and match day, right? And this too is calculated using specific statistical measures such as log likelihood and Cohen's d. However, you of course don't need to know what those mean precisely. You just need to understand that these statistical measures are designed to highlight certain peculiarities of one data set compared to another data set. And then there's also something called multivariate analysis, where we will use a whole set of linguistic parameters and try to determine how and in which sense a certain data set is clustered with respect to all of these parameters, right? So we will, for example, find that academic writing is characterized by heavy noun phrase density, also heavy use of passive, whereas a conversation is clustered by frequent first person pronouns and private verbs and so on. And there has also been one particular Polish scholar called Stanisław Gość-Rostkowski who researched that with respect to legal language. And he also found that legal language tends to cluster towards the academic side, right? So a lot of use of passive long phrase sentences, also use of rather archaic language sometimes as well. And this is then clustered together as a whole style, legal style, right? So this is quite interesting as well. Now, these methods, I would say, are still the most important ones used in corpus analysis, and I'm going to show you in practice how I use them with respect to a certain research project. Before I do that, I want to talk about 3 different types of corpora first, and in particular with respect to the question what they represent and which kind of discourse they aim to represent. And something we already worked with extensively, I would say, during the last talk were general language corpora, right? And general language corpora, they aim to target everyday language, everyday discourse, right? That's what they want to represent. And that's also, of course, the most difficult endeavor, because what does everyday language mean at all? And therefore, the most important thing is that the samples, the pieces of language that they use, they ought to be as balanced as possible. So every kind of style, register, genre, and so on needs to be represented in these general language corpora. And since it's so complicated to build them, they are also the most accessible. And therefore, this was also the field of corpus linguistics that I prefer to use in teaching, because there are several online platforms where you can actually use and analyze these corpora with, and you don't need specialized corpus software necessarily to do that, right? And so a few popular examples of general language corpora that aim to represent general everyday language use is the BNC, the British National Corpus, and there's also the BNC 2014, which represents recent language use in British English. There's also the COCA, which represents American English, contemporary American English, and there's also an Australian one. However, this data set is a bit old already, the ICE-AUS. So this might not be as representative for modern Australian English as one might think. Now, there are several applications of general language corpora in the law already, and I would say the most researched one and the most established one in legal corpus linguistics is actually this, which is determining the meaning of legal terms with non-legal origin, the so-called ordinary meaning, right? And last time we, for example, talked about the ordinary meaning of the term carry, right? Carry a weapon. If I carry a weapon in my car's trunk during a drug deal, am I then carrying a weapon in the sense of the law, which would lead to an enhanced prison sentence, right? Because it might be more dangerous, the drug deal I'm conducting. We then used the British National Corpus to further elucidate the meaning of to carry, and we found that well, there was actually not too much corpus evidence where carry was used in a sense that did not relate to body closeness or did not relate to a metaphorical use. So, right, it was probably a problematic conclusion to use the word carry when I'm merely having a weapon in my trunk. And there are all kinds of other instances where using general language is helpful. For example, what we also discussed last time briefly, only in the discussion, however, I believe, was once again relating to weapons and to the Second Amendment of the US Constitution, right? What does it mean to keep and bear arms in the sense of the US Constitution? And we found that, well, if we adopt an originalist perspective and say, which is of course controversial, that the original language use back in 1791, when the US Constitution was adopted, is the one we need to opt for, the one we need to use in order to determine the meaning of keep and bear arms, then this actually supported only a collective right of militias to keep and bear arms and not an individual right of one individual person, as it is pronounced by the US Supreme Court in the Heller decision, I believe. And now these are all ways how to use general language corpora in the law. We can also apply general language corpora when we want to further determine the meaning of individual legal terms that explicitly relate to language meanings, such as, for example, the question, what does incitement to violence or hate speech mean, right? In Germany, at least, incitement to violence is punishable. And last time also we discussed briefly whether the slogan "Foreigners out" in German, of course, has to be understood as inciting to violence. And here too, we used corpus evidence to further dissect and understand whether this relates to incitement to violence vis-a-vis certain groups or minorities, right? However, what I want to focus on today is the use of specialized corpora, and in particular, authoritative legal corpora. So a specialized corpora is, as the name suggests, of course, a corpus that aims to represent special kinds of discourse, such as a professional discourse. We might want to know what builders talk like, for example, or of course, what the legal profession talks like, what lawyers talk like, what courtroom language sounds like, and so on. But if we want to go as close to typical legal questions as possible, then I believe the most promising use of specialized corpora is the use of authoritative legal court corpora. So corpora that represent the discourse of certain courts, such as all English courts, or certain instances, or only criminal courts in a certain country, and so on. And they are authoritative because we are interested in the authority with respect to certain legal meanings that they pronounce on a regular basis, right? So this is closest, I would say, to the regular endeavor of understanding the law that lawyers, legal professionals every day are dealing with. And in this respect, it's a bit harder to gain access to corpora, but there are already some. For example, the COCELT is a corpus that represents contemporary English legal decisions. And so if we want to know what English courts have to say to a certain legal term, then we might use this one. Or the COSCO US, it represents opinions of US Supreme Court judges, or the OALC is the Open Australian Legal Corpus. And there has also been one corpus constructed right here at this university, of course. Now, as I already said, these specialized corpora, they can then be used to determine the meaning of legal terms and concepts. And that's what I will show you in a second. However, as a last category, we can also use parallel and comparative corpora. Parallel corpora, comparative corpora are corpora that are aligned in some way. And in case of translation corpora, in case of parallel translation corpora, a parallel corpus consists of aligned sets of translation in a source and target language. And then we can see how certain texts are translated in another language. And one example that relates to legal translation is the Eurolex corpus that consists of European legal documents that are translated in all European languages, right? And here we can do all kinds of things with this as well. We can, of course, check the accuracy of legal translation. So we can do word field mining. We can talk about that in discussion if you want to. And we can also do comparative research. And now, finally, I want to discuss a large piece of my research where I combined the research into the meaning of legal terms and concepts with comparative law, so with comparative research, right? However, one last slide. How do we build specialized legal corpora? Sometimes we need to do that. And let me just show you how I did that. Once when I built a corpus for that represented all decisions of the International Center for the Settlement of Investment Disputes, because we did not have one in this respect. And the process is quite straightforward, I believe, but it requires some coding. So you need to collect data first. You then need to rename the files that you collected using a web crawler. Then you should typically use an optical character recognition software in order to extract all text, convert it in the best case to XML, add some metadata such as case text or doc URL content, so a URL where you can download the original file, and then validate it. And this is how, as a best practice, a corpus file would then look like. You can see there are meta tags that carry the name of the corpus, ICSID award corpus. There are case numbers, and there are also URLs that you can download, and each word and also each punctuation mark is wrapped with a text, right? And here you can see that it also worked using a collocation analysis where I checked how the term environment was used in the ICSID corpus, and I found that it was not used in the sustainability sense, but instead it was used as relating to business environments, right? Predictable business environments, hostile, risky, insecure, stable, unstable business environments, right? So a completely different sense of environment there. Okay, so this was just a bit I wanted to say how to build a corpus, but now finally corpus-based comparative research. How do we do that? So I chose to talk a bit about this topic because I think it combines beautifully all kinds of corpus methods into something that has, as far as I can see, never really been done before. And what I opted to do is I wanted to compare two legal instruments, one British and one German one. The British one is contempt of court, and the German one is called Zwangsgeld or Ordnungsgeld. And why did I want to do that? Because if you read legal literature, then you will typically find definitions such as those. Contempt of court is something that addresses sanctions undermining court authority, including civil and criminal cases. And Zwangsgeld is a coercive fine to compel compliance with court-ordered obligations. And this sounds quite comparable, right? So in both cases, we are talking about court-ordered obligations. Someone did not comply with it, or at least might not comply with it. And then there's a court-ordered fine to ensure compliance. So it sounds quite comparable. And that is why also in European legal literature, typically it is claimed that both concepts, contempt of court and Zwangsgeld, are somewhat close equivalents, right? And so then my research question was, does corpus evidence reflect this? Because I was skeptical. And why would you do that apart from pure academic interest, of course? Well, comparative research is, at least in Europe, something that is actually quite important with respect to harmonization projects, right? Because quite often there is EU law that has to be implemented in all kinds of jurisdictions. And yes, the UK left the European Union, but Ireland is still in. So we still have a common law jurisdiction. And so we still need to bring together these different kinds of understandings, of legal understandings, and we need to understand what the shared essence is, and also what differences we might have, right? And so this is definitely an important practical question as well. And also what we can observe in Europe, at least, is that courts regularly will consult the jurisprudence of other courts of other states, just to get ideas, to be inspired a bit. Now, how do we go about doing corpus-based comparative research? Now, as a first step, I did a translation analysis. And this is, of course, perfectly suited for comparative research because we can assume that legal translators know which legal concepts in the target language represent an equivalent concept in the source language, right? So we already have in Europe, at least, a whole bunch of translated legal texts. And if we want to know if two legal instruments in two legal systems having two separate languages are comparable or not, then we should analyze how they are typically translated. And therefore, I used the EuroLex parallel corpora in this case, which, as I already said, consists of aligned translations of European legal texts and court cases. And for translation analysis, as a first step, we should come up with a set of target terms that our analysis starts off from. And here you just have to do a bit of reading, and then you will find that certain terms reoccur all the time. In this case, however, I only found 3 terms that occurred all the time in Zwangsgeld, Ordnungsgeld discourses, so in the German discourse, and 2 terms that reoccurred all the times in contempt of court discourses, which was contempt of court and just simply contempt or contempt cases, right? So my set of target terms was quite small. And then as a second step, you will then generate a list of potential translations in both language. And this set should be as extensive as possible so that you can cover all kinds of potential translations in the in the target languages. And so how can you do that? You can simply use online dictionaries, and there are Python APIs there as well, where you can extract them automatically, and also so-called word vectors. Word vectors are sets where certain terms are translated as a string of numbers, and these strings of numbers also encode similarities between other words, right? It is also an important building block of large language models. And with these 2 tools, you can then create exhaustive sets of potential translations. And so for both languages, for both starting points, I generated more than 300 potential translations, right? And many of them are, of course, quite far away. But as I said, it's only to cover as many potential translations as possible. And then you analyze the most frequent translations, and this looks like this. If we analyze contempt of court target terms, so we analyze how contempt of court is typically translated in the EuroLex corpus, and since I found that there aren't actually many occurrences of contempt of court in the EuroLex corpus, I substituted it, or I extended it with subtitle translations, which is the Opus corpus, the open subtitle corpus, to just have a bit more data material. And in this case, I found that actually contempt of court is in 55% of the cases only translated as Missachtung, which is disrespect, or Geldbuße, which is fines, penalty. And you can see Zwangsgeld, the supposedly counterpart of contempt of court, occurred as a translation only in 5% of the cases, and due to the overall low frequency, only in 2 cases as in absolute occurrences, right? So this already should make us skeptical with regard to the prevalent hypothesis that contempt of court and Zwangsgeld are counterparts, right? So this is already quite strange. It gets even stranger if we take the other direction, the other translation direction. If we analyze how Zwangsgeld is typically translated in the Eurolex corpus. As you can see, contempt of court does not occur once in the top, how much is it? 1, 2, 3, 4, 5, 6, 7, 8, in the top 8 translations, right? It does not occur once, but instead we have terms such as penalty, fines, infringement, breach, dismissal, disregard, and so on. Those are frequent translations, right? But contempt of court does not occur once. And something you can also see is that the great difference in frequency, right? Zwangsgeld occurs way more often as a source term than contempt of court occurs as a source term. So this points also to a quite pronounced difference in overall importance, because remember, we're dealing with the same corpus. It's the Eurolex corpus, right? It's the same data set. Okay, so as I said, contempt of court and Zwangsgeld, Ordnungsgeld are rarely considered equivalent concepts in legal translations. And in addition to this, due to the higher overall frequency, 53 times higher likelihood, we can assume that the concept of Zwangsgeld is of greater overall importance in German legal discourse than contempt of court. Now, this is, I would say, one interesting first result. And the question is now, is this supported by further corpus evidence, right? Let's check out other corpus methods, because this is in general an approach that I advocate for. Don't just use one corpus method, use as many corpus methods as possible, because all of them represent different shades of analysis, and with all of them you can generate different shades of meaning. Let's consider frequencies for a second. And here too, you can see that the frequency in British legal discourse is, if you compare it to the overall corpus frequency as in relative frequency, so you just look at the relative frequency per 1 million tokens, it is actually still quite pronounced. So you can see right there, in particular compared to the relative frequency in general British English, that contempt of court is definitely a very legal term. It's legalese, right? It's got a high specificity within legal discourse. And the same is true in German for Zwangsgeld and Ordnungsgeld. In formal written German, it occurs less than 1 time per 1 million tokens. And in legal German, as represented by the so-called Jurico corpus, it occurs 16 or 7 times. So we can learn from that. Yes, they are quite legal terms, with a high specificity. But it does not tell us too much with respect to our initial research question, but it's still, I would say, quite interesting. More helpful with respect to our research question is the analysis of concordance lines. And these concordance lines look like that. You will find the term, the note, the term of interest in the middle, and then you'll find the left and right context to the left and to the right. And what you should do then is you should study it. If it's a very limited set, then you can study all of them. If it's a very large set, then you should study a random sample of maybe 100, 150. And right here, you can see the German ones, just so that you know that I analyzed them as well. And then you should code them in a certain way. So you should search for reoccurring topics. And so what I found is that there are some similarities, yes. Contempt of court and Zwangsgeld, they both occur in civil and criminal court proceedings, so they are quite important in all kinds of proceedings. However, one pronounced difference was that contempt of court was usually tied to previous non-compliance with court order, so it was more of a repressive instrument, whereas Zwangsgeld, Ordnungsgeld was rarely actually applied, but only threatened, right? So it was more of a preemptive instrument that, was a threat to ensure future compliance. whereas contempt of court always related to an offense, to an instance of contempt against the court that had already happened, right? And so this was a very pronounced difference that was very visible after coding 100 concordance lines each, or sorry, with respect to contempt of court, it was just 26 or so. So I coded all of them, and then a random set of 100 concordance lines of Zwangsgeld, Ordnungsgeld, right? And so I found these differences. And something else that you can do, which then again showed more of a similarity between contempt of court and Zwangsgeld, Ordnungsgeld, was an analysis of the sentiment, right? So in this case, you use a sentiment analyzer. In this case, it was the BERT-based model. You have to use Python for that. And you just check, does the sentiment analyzer categorize this certain term as occurring in a predominantly positive or a predominantly negative context? So you're trying to determine the semantic prosody of a certain term. And right here, we could find that contempt of court typically had a sentiment rating of 1, very negative. The same is true for Zwangsgeld, Ordnungsgeld, 1, very negative, which then again points to a similarity, right? And it also makes sense if both relate to fines, to coercive methods, even if it's just a preemptive threat. Those are all negative concepts, right? So here, I would say a shared dimension of negativity is visible. Something else I like to do, and I think it should also belong into each corpus-based legal analysis, is the analysis of collocations. And here too, we can see the tendencies that have become visible so far. And if we just consider the co-called collocates, and in this case, I generated MI2 collocates, which is a statistical measure, a so-called AM, association measure, which highlights both exclusivity and frequency, right? Because if we would only generate collocates based on frequency, then we would end up with a large set of function words such as to, on, about, the, and so on, because they are just most prevalent in language in general. So instead, what you have to do is you should use another association measure than frequency. For example, MI2, I think this one is a pretty good one, which really very well balances frequency and exclusivity, right? Because there are some association measures that weigh exclusivity they give it a quite great weight. And in this case, you will then end up with very rare combinations, but they don't necessarily reflect the overall trends in the discourse, right? You don't want to know what are the rarest combinations. You want to know what are the most frequent and also most exclusive ones at the same time. And so MI2 really strikes a balance between exclusivity and frequency. And now what you can see is that after we set a minimum collocate frequency, in this case, it was sufficient to simply show more than 4 collocates because the co-called corpus is not that large. We end up with terms such as proceeding, sentence, enforcement, guilty, jurisdiction, order, or court, which very much highlight the procedural environment right here, but also I would say the penal nature, right? The sanctioning nature, in particular by using terms such as guilty, right, or sentence, enforcement, and it also shows that something bad happened already, and then you have to react to that, right? And so I think these shades of meaning are also very well represented in this collocation graph. Now, if we compare that to the German collocates, then we will find, I would say, a completely different picture. Here, I used the same association measure, MI2 once again. I removed function words, but as you can see, I had to set a completely different minimum collocate frequency, more than 350 collocates. Right before it was 4, now it's more than 350, which of course makes sense because once again, Zwangsgeld, Ordnungsgeld occurs very often in the corpus. And if you don't want to have a super overpopulated collocate graph that is not readable anymore, because imagine if I had a minimum frequency of only 5, then I would have 500 collocates surrounding the node, and it would not be readable at all. You would then need to study the list form only. But if you want to keep your collocate graph readable, then you have to set an adequate frequency, which was 350 in this case. And here you can see several German terms, such as Festgesetz, for example, which is fixed, fristgerecht, which is due time, in due time. So it's very much about the time when this is to be paid. Einzelfall, which is individual case, in each individual case. And if you study the concordance lines surrounding these collocates, then you will find that typically it is once again a perspective into the future, right? For each case of non-compliance in the future, a threat of some X is threatened. So these are typically the reoccurring contexts. And you can also see that there are reoccurring numbers, which points to a highly reoccurring pattern and formulaic pattern of reoccurring fines that typically are threatened if someone might not comply with the court order in the future. Also angedroht, Androhung, threat, threatened. You'll find currencies and so on. And so this, I would say, paints a completely different picture, right? Terms such as threatened, fixed case, on time. This really focuses on the preemptive nature for each individual case, the threat nature, and not so much on the repressive nature right here. And that's basically what I already said, right? The contempt of court collocation analysis shows that it is typically a sanction for past non-compliance. It has a penal nature. It relates to individual occurrence. You did something bad and now you're in contempt of court, and now a fine of X is fixed. And whereas the Zwangsgeld, Ordnungsgeld relates to threats to improve future compliance, reoccurring amounts, and it's very much about future timely execution of court-ordered duties. And something else that you can really see, and that is also one of the reasons why it's so much more frequent, is that it is quite often included as a standard phrase in many court judgments, simply if the judge might think, well, maybe there won't be compliance in the future, so I better set a Zwangsgeld. And this is something that is not done in with respect to the contempt of court instrument. It's only fixed when there is actual non-compliance with court orders, which I think really explains the frequency difference, right? And this is also represented, I believe, in the analysis of content-carrying n-grams, right? And I already mentioned how n-grams are phraseological uses of language. And if we extract n-grams, so phraseological uses of language that contain our two search nodes, then we will find the following structure. With respect to the content-carrying contempt n-grams, we will find stuff like guilty of contempt, proceedings for contempt, be punished of contempt, right? Once again, procedural, penal, and also quite interesting, ridicule or contempt. That was the second most frequent n-gram containing contempt, and it shows that quite often there has been a case of ridiculing the court, which led to a contempt motion. We don't have that at all with respect to the Zwangsgeld, Ordnungsgeld n-grams. Here it is very much about the amount, determining it, the threat, so once again, the difference between preemptive and sanctioning nature becomes quite clear, I would say, right? The most frequent Jurico n-grams focus on amount, imposition, threat. Most frequent Kokelt n-grams on finality, actual enforcement of already happened contempt cases. I also did a keyword analysis, and I believe I presented a keyword analysis last time with respect to the term negligence, and I believe, yes, last time I showed you a negligence keyword list. And what did I do with respect to this keyword list? Well, I compared the legal discourse surrounding cases where the term negligence appears at least once with general legal discourse. And right there it was quite successful because our keywords really highlighted all kinds of common law conditions of the tort of negligence. I did this here too, and as a good researcher should do, I'm also reporting on my failures. And so I could not produce meaningful keywords due to very small effect sizes with respect to contempt of court and Zwangsgeld. So, and here too, I tried to compare corpus files that contained contempt of court or Zwangsgeld at least one times with general legal discourse as it was represented in my specialized corpora. However, the small effect sizes show that the discourse surrounding these terms is not specific enough to exhibit any statistically significant differences. Yes, yeah, I would say this is quite an interesting and important result as well, because it indicates that overall both terms, they have a minor role in the discourse, so they don't modify the discourse within certain corpus files as much that it becomes visible. Okay, and now I'm already at a point where I can summarize what I told you today. I think we can see that corpus evidence indicated pronounced differences between contempt of court and Zwangsgeld. Both are coercive measures, yes, pronounced by court, but they differ significantly in importance and functions. And the claim, I think, that they are close equivalent, as it is present at least in European scholarship, is successfully falsified. And I'm actually using the term of falsification right here in the Popperian sense, because we're using empirical evidence. We are falsifying a claim about legal reality, which is that contempt of court and Zwangsgeld is more or less the same. And I think using this evidence, we can see that this is not the case. And the next step would then be more close reading traditional qualitative analysis, right? And so that has been my presentation. I hope you found it interesting, and I'm now very curious if you have any questions.
I'll just pop my head onto the screen as well to say, firstly, thank you very much, Adrian. Last week when Adrian spoke about using this kind of methodology with his students in class, one of our colleagues wrote me an email to say she loved it. I haven't passed this on to you yet. She loved it because she could really nerd out. And I think the same positive compliment could be given today. Lovely, technical, but so clear, so applied, really interesting. So I wanted to invite people online. You're welcome to put up your hand and speak. The technical facilities in this room are very good, so we can hear you if you ask a question, or you can write it in the chat and then I'll read it out to Adrian, and people in the room, of course, as well. If you have a question, we'd love to hear from you. And while people are just thinking of questions, I will also just give a little shout out to Laura, who's here on the screen, who used to be our colleague at UTS, who co-runs the network with me, and who, in a lovely surprise for you, has been live posting on Blue Sky your presentation. Oh, so we have that extra record of it for people to engage with after as well. So
yeah,
thank you very much, Laura. I'll just see if there's questions here. Mira, do you have a question? You've just popped your video on. Oh, okay, but nice to see you. Okay, well, I had a question just to start with, and it comes back to what you said here, using this sort of, you know, scientific terminology or concept of falsification. And I wanted to know how that's been received when you've published this kind of work or presented it to other scholars, that sense of it being sort of so robustly empirical that you can actually falsify a claim in legal scholarship. Do people take well to that kind of pronouncement, or are people skeptical?
Yeah, this is a very good question, because I felt that people are very divided in this sense. So I don't know if this is the case in Australia as well, but I tend to observe that at least in Germany, we have some people who really love to, that the law is a bit like philosophy, in that sense that you're only talking about plausible or implausible answers, right? And people who generally subscribe to this way of thinking, who often will also focus on individual facts on the case, and who will tend to restrict theoretical abstraction a bit, they don't really like that, because I'm removing the law from philosophical thinking a bit, right? However, and I would say this is a general trend in Germany, and it's also something that inspired me towards this field, is I would say an increasing amount of people is a bit annoyed with the indeterminacy of law and of legal language, and they also consider it problematic with respect to the search of justice, because you can also always argue that something is implausible or plausible. And in fact, they are trying to answer empirical parts of the law with empirical methods and using strict scientific rigor where it is possible. It's not possible everywhere, but I believe it is possible in more fields of the law, in particular where it relates to language than we think. And so overall, it has been received positively, but it's also polarizing because it really touches upon the fundamental question if the law is a real science in the Popperian sense that deals with falsifiable research questions, or whether the law is akin to philosophy, to a hermeneutic endeavor that is not science in the strict meaning of the term.
Thank you. Laura, you have a question as well, please.
Thank you. Thanks so much, Adrian. That was such a fascinating presentation, and I definitely agree with what Alex said. It was so clear, and you were explaining so many technical things, and I feel like I hopefully have learned something from it. But I couldn't help being so, it was so striking, I think, in this particular example that you shared, how much we have this idea of kind of language being something that can be studied, I guess, in isolation or understood in isolation. And I think your analysis really showed how important it is to think about social context of language and how it only really has meaning in relation to that. And it's quite interesting because you used corpus analysis, which is looking at texts and at words and, counting and measuring things, which could be, presumed to be kind of separate from social context. But actually, I think your findings really support this idea that, we can't make sense of different terms and their meanings without considering the social context, because you've talked about, these two terms that are compared and suggested that they're similar, but you've taught me something really new, which is that in the German context, the German legal context, and the British legal context, those terms are used in really different ways, right? There's this significant difference between something that's, applied on an ad hoc kind of reactive basis in the British system in terms of, you've done something wrong and now contempt of court applies. And then talking about what happens in the German legal system, which is much more, it seems to be more systematic and preemptive, or kind of, a general warning that's given much more often. And I think that's where it's looking at these ideas of being able to directly translate things, it really helps to refute how often that is possible, or how that can be possible, without consideration of the social system or the legal system in which those terms are being used. So I don't know if that's a question per se, but that's something of real value that I took from your presentation. And I guess the question kind of stemming from that is in regards to your very final sentence on your final slide, where you talk about your next steps or someone's next steps for future research in this regard. What kind of qualitative analysis would help to kind of explore this finding or enlighten this finding further?
Yes, thank you, Laura. And I think this is an excellent point that we also touched during the teaching seminar last week. And I just want to highlight this because I do fully agree with you that corpus linguistic methods show the dependency from social contexts, right? And I think corpus evidence strikes a balance in the law between, on the one hand, excessive relativism, where people will argue, well, legal terms can basically mean anything that you want them to mean. And on the other hand, also an approach to language that might be considered Hartian, where you would say, well, there is always a fixed core of settled meaning of a term, and we can't argue about that, right? And then there might be penumbral questions of meaning that we can argue about. And so I think corpus evidence shows that both perspectives are not true, and that in the end, context dependency, which is a pragmatic enterprise, and hence, once again, the intersection between law and language, why this might be the the best, or at least a very adequate perspective on the law, which considers these social dependencies. And yeah, the next step, I think, should always be in corpus-based legal research, a close reading of the sources, because due to the nature of corpus linguistics, we are always considering things from a very abstract and high-level perspective. And we might overlook nuances that are hidden in deeper layers of the text, right? So just remember, the colloquial analysis only considers a span of 5 words to the left and to the right? And there might be cases where nuances of meaning are hidden somewhere else in the text. And still, in many cases, corpus methods will not be suitable to grasp these nuances of meaning, because even if we take bigger concordance or collocation windows, we might still overlook it, or we might have a situation where we would have too much noise in the data due to other findings. And so we should always be aware of that corpus evidence might point us in right directions. It might point us in previously overlooked directions, but it should not be used as a standalone device simply due to this more complex nature of discourse, of legal discourse, which might not always be reflected in the methods we use.
Thank you, Adrian. And look, we're running to the end of our time, but I wanted to ask you to say, if people want to follow up with you more, they want to join you in your next steps of your research. Adrian himself is continuing this in his habilitation project and forthcoming book back in Germany. But where is it easiest for people to find you? Are you on social media or via your work email? Where can people find you?
Yeah, I think best is if you just write me an email. So I am on LinkedIn, but I'm not really curating my profile there. So just write me an email. And also you will find that I haven't yet published on this topic because, as Alex mentioned, it relates to my habilitation thesis, which is the second big book that you have to write as an aspiring professor in the German academic system. And I will hopefully publish this one in early 2026, but this will be in German then, of course, and it will take a bit until there is until there are English papers or anything on that topic. But they will be coming, but they are not there yet. No.
Well, we'll await them eagerly. And just as a final reminder, something coming up quite a lot sooner. In just 2 weeks, we have the second part of our celebration of 6 years of this wonderful Law and Linguistics Interdisciplinary Researchers Network. We first met on this very day 6 years ago at the University of Sydney. And so we're celebrating the establishment and the ongoing community that we've built with both your speech, and then on the 14th we have Helen Fraser from Melbourne University coming up here in person to UTS to run a law reform workshop. Laura and I will also run a workshop on next steps for the network, and both of those will be hybrid like today, and then we'll have an in-person lunch, and we're really hoping members of the network who are in Sydney can at least join us for a chance to just have a chinwag and hear more about each other's research. So join me please in once again thanking Dr. Adrian Hemler.
Thank you.
Thank you to the comments online, and we'll see you later.